Hello, everybody. My name is Jakub or Kuba. So today I'm not going to speak about AI, unfortunately. I think that I'm one of two lawyers who do not speak about AI. I'm very proud of it, frankly. The choice of my topic is not really fortunate, as I came to this conclusion that I'm gonna speak about transactions, or at least the part of the transaction process which is due diligence. And well, there are no transactions right now because we have a crisis and so on. The VCs investments are cut, but anyway, maybe this will reverse in like 2, 3 years, and then you'll know where to find me. Okay, so I just want to ask one small question. How many lawyers we are here? Okay, like 50-50. Okay. So let's make it like that. Half of my presentations will be boring for lawyers, and half of it will be interesting. Okay, that's me. Okay, so briefly, what I'm gonna speak about. The essence, what is due diligence? Overview of how the typical due diligence process looks like, the importance and non-importance of due diligence, why is it important, why is it not important, how to prepare to the due diligence, most important areas that are checked during the due diligence process, some practical do's and don'ts, and some selected cases from my vast experience. Okay, so what are we talking about here? What is due diligence in general? Due diligence, it's like a kind of legal name for a process of checking a condition of a company. Basically of a company in general, but mostly of a target of some investment, some M&A transactions, acquisition. Due diligence may be run in various cases. When you check your partner, when you check your investment target, when you check in any cases when there is a, let's say, need for verification of a company. So due diligence is a process of checking a overall condition of a target, which is a company, a business entity. So this verification may cover different areas. You may have legal due diligence, and this is what I'm going to speak about today. You can have also financial due diligence, so run through the numbers, accounting due diligence, the same, basically, and business due diligence, so how the company is generally set in a business environment, how well does it do business. We have, the due diligence processes may, like a bit of theory, they may be divided to these like areas that I just mentioned: legal, financial, business, and so on. And of course, it may be also divided to who runs due diligence. Is it a buyer or a vendor? So you may check the status of the company that you buy, but you can also check the status of the company you sell. It may be your own company. I'm going to speak about it a little more in a few minutes. So what is the purpose of due diligence? So for the buyer, of course, is to check whether you do not buy some, in Polish we say trup w szafie, but a dead man in the closet. So whether there are no hidden problems in the company. Of course, there are always some hidden problems, but let's say for them not to be too disturbing, too material. And for the vendor, of course, it's to prepare for the investment, for the M&A, for the process. So to check whether you do not have any trup w szafie, and to prepare for it. So if you have any, you need to clean it, so it doesn't impact the transaction. So what is checked? In general, everything can be checked. So for now, I would say that the entire documentation of the company, the entire standing of the company may be checked. And I'm gonna delve into a bit more details about it in a minute. But in general, every area of company's activity may be checked. a couple of not so stupid questions that I was asked by some clients that we helped in during the due diligence process. So who's the subject of due diligence? The founders of the studio or the studio itself? The answer is the studio, but there are some cases where some trup w szafie may, relate to the founders themselves. So there might be some cases where the problem, the issue, the red flag to the investment is inherent to the founders rather than the company. But generally, the studio is the subject of the due diligence process. Is it necessary? No, of course, it's not necessary. Like you buy a car, and you do not have to do a test drive. But usually, when you do, you're going to make a better decision. How this car is generally behaving on the street. Do you like it? Are there any problems? Are the engines smooth? Does it have enough power? So, like, it's not really necessary, but you should do it. If you gonna invest a bunch of millions of your cash into something, you better check it. So if the target of the investment, if the investment ticket's like $50 million. It's not a big. It's not a big ticket, not a big money. You better invest some additional, 50,000 zlotys into some basic due diligence to see if you're not buying a trup w szafie. And I was once asked by the client, "Can I run a due diligence of my investor?" And I thought, God, it's a stupid question. But then I thought, my second thought was, no. You're stupid. It's not a stupid question. It's a brilliant question. Because, if you are invested in, then you should be able to also check who invests in you. But the business practice is generally the due diligence process, it's like one way. So, of course, you may ask your investor or your counterparty for some information. But if they're going to invest their money in you, it is them who are checking you and not the other way around. But of course, it doesn't mean you should not collect as much information about the investor as possible. It's sometimes necessary, and it's very very good practice. Okay, so how the typical due diligence process looks like. The parties involved are, of course, when we are talking, of course, about some VC investment in a gaming studio, because, of course, as I said before, due diligences can be run for various different occasions. We are talking about the VC investment in a gaming studio. So you have the founders, so the guys who want to make money, have some idea, have some IP. They're hardworking, of course, and they run the studio. The studio itself is a target of due diligence. It's the company that is X-rayed, and these two stakeholders have their advisors. They are legal, accounting, financial, business. These are usually 4 areas that you should be advised on when you're undergoing due diligence. Of course, you have the mighty investor, so the guys that are throwing the cash on you. And you have their advisors. They are their pit bulls, usually. Legal, so the bad guys. We're the good guys, legal. They're bad guys. The accounting, financial, business, of course. Generally, the entire process of due diligence is, for legal due diligence, is the good legal guys versus bad legal guys. And it also applies to the entire investment. Yeah? So we're going to battle each other for the best conditions for our client. So when does it start, the due diligence? Usually, I wrote there after signing the term sheet, but it's not necessarily the only option. So the X-ray starts basically when there are some papers signed on the table. Some will of investment, something is, it's more than just words, more than just numbers. There is some, a fixed will to go further. then the due diligence starts. Usually after the term sheet is signed. The ending date is usually before signing the deal documents, of course. So before the deal is done, the due diligence should be over. It doesn't mean that it cannot continue after this time, but the general let's say portion of the due diligence should be over before the deal documents are signed. How long does it take? It really depends on the deal, but I would say that from a couple of weeks to a couple of months. It can be from, I don't know, 5 weeks to 4 or even sometimes 6 months. But it really depends on the deal that we have on the table and on the investors. Some investors can just run through the documents and they're like, okay, you're fine, well, let's go. And some of them can be very meticulous. It also depends on the bad lawyers, the investors' lawyers. Yeah. So here's a bit of like a glossary with a chronological order. So the due diligence, it usually starts with a request list. It's a list of the documents that are needed to pursue the due diligence. So you write all the documents that you need, all the resolutions, agreements. I'm going to talk about a bit later about what the documents are needed for due diligence, but generally all the documents should be listed in the request list. There is something called materiality threshold, which is it doesn't really always apply in the VC investments. Usually it's a number that reflects some amount below which the issue in question is not really material. So let's say you have some risk, that the legal risk that would, if it cracks down, it would, I don't know, cost you like $20,000. So if the materiality threshold it's $30,000, the issue in question is below the materiality threshold. Sorry. So it's non-material, it's not important. And below this materiality threshold, it is usual that these issues are not checked. They're considered not significant, not material, and they're like kind of skipped. But it's a theory, and sometimes, as I said, the VC deals do not have materiality threshold, or they have a very low, so like everything qualifies as a material issue. VDR is a virtual data room. It means some I don't know, Google Drive or something like this, where all the documents for the purposes of due diligence are stored, and they are disclosed to the other party. I said Google Drive, but don't do it. Don't put your confidential information on Google Drive. Just set some really confidential virtual data room. So disregard this Google Drive, please. Management session. When there's a due diligence, when some documents are disclosed, they are reviewed by the lawyers, they're checked. There's usually some need to ask a couple questions to the management board, the founders, the guys who are behind the studio, because not everything can be disclosed in documents. So there are some documents that may be not really their purpose or the context may not really be visible at the first glance. So usually lawyers or some other advisors, they have to ask some questions to the founders. And that's the management session. So when you ask the questions to the people who are in charge, you can like get some context to the documents that you review. DD report, it's like a center point of the process. It's a report that summarizes all the issues that are found, and it's really in the DD report everything that you found as a lawyer, as a person who runs a due diligence. should be disclosed. So everything should be there. If you miss something, if there's some issue that you didn't write in the DD report, it's considered that you don't care. So the lawyers produce like hundreds, thousands of pages of DD reports just not to be accused of missing something or hiding something. So that the DD reports are usually like, I don't know, 100 to 100 pages, at least for the bigger investments. And from the DD reports, we're coming smoothly to the red flags. Red flags are the issues that are material for the deal. They are considered something that may like throw the deal away. The issues that are so big, so crucial, so material that they can take down the entire deal. Disclosure letter. It's kind of legal theory of what means that something is disclosed. But in general, if you disclose something, you show the issue to the other party. You say, okay, here we got some trup w szafie. Please look at it. It's dead. It stinks. We're going to fix it. But right now, it's dead, and we're trying to fix it. So we're being honest. We put everything to the light. We don't hide anything from you. Let's talk about how we can fix it. Right now, consider this disclosed. Consider yourself knowing about this trup w szafie. It's a pretty. It may seem not important, but it actually is, because if in the investment deals, if you disclose something, of course, provided that the deal documentation is properly written. Sorry, if you disclose something fully and fairly, the other party cannot claim that it didn't know about it, and it's very, very important if this trup w szafie raises further to the point when it deals some damage to you or the investor. When this issue arises to the point when there are some actual financial damages. So you can say, I told you about it, you accepted it, you knew about it. You didn't push me to clean it up immediately, so now it's our common issue. You can't make any claims to me. But this is just one way to deal with it. Not all the deals envisage this mechanism, let's say. Position signing, closing, they're not really part of the due diligence. These are names for like signing all the deal documentation. So the signing is usually like a preliminary phase, or the preliminary documents are signed, and closing when the investment's finished, all the papers are signed, people are going to get drunk out of joy. And before signing, before here, or at least before here, the due diligence should generally be closed. Okay. Why is it important to run a due diligence or to become a subject of due diligence? So, because of course the process may be scary, because someone is going into your home and looking at all your dirty stuff. It may be scary, for at least if you're a founder, if it's your first deal, first round of investment. You might be a bit like confused, scared, but due diligence is really an opportunity, because at least if the investor is paying for your lawyers from the ticket, because this is a great opportunity to get some let's say external opinion of your business legal standing. So it's like a second, third date, because the first dates, of course, are the numbers, the ticket, and so on, and the due diligence is like a second, third date. We all know what is made on a third date. So it's like the moment that you can really step away and kind of let other people see how your business's legal standing is. And I think it's really, really important, in particular where you're a young founder and when you don't really have this legal experience. And again, you can learn what's wrong with the legal side of your business. The third point is that it might generate legal additional costs and have the impact on the investment amount. So if you consider that this is not important, it may backfire because there might be some trup w szafie that the investor would use to say, okay, you have some problems. We need to either lower the ticket or, for example, I don't know, put some our guys into your management board because you clearly don't know how to handle your business. We're going to do it for you, so we need to have some additional powers in your company. It's not like a typical situation, but it's kind of an argument to for the investor to use that would like for the investor to try to gain additional power over your company. Last but not least, if you're a game dev studio, it might impact the operational side of your business and the development process. I'm gonna say about it, talk about it a little bit more, but in general, if your IP is checked, if there are some problems with your IP, there's some stuff, I don't know, the copyleft licenses, or you don't have the proper licensing structure to the stuff that you use. You might need to even erase some of the faulty code, or I don't know, some plugins run on the faulty licenses, and you might need to replace some of these code elements with the proper ones. And this is a part of the development process. And nobody really likes the legal side to impact reality, impact game development, which is of course the most important thing if you're a game dev studio, but sometimes it's necessary. And red flags may be a blocker of the transaction. So these really material issues that you may find in the worst case scenario, the investor might say, okay, I'm not gonna do the deal with you. It's clearly some real legal issues that that were there, and sorting it out would take so much money and so much time that I'm backing off. In VC, it's not really the case. There are hardly situations where the investor says, I'm not gonna do it. But in the bigger M&A transaction, it sometimes happens. Okay, so why is it not important? Why it's not like the due diligence is the center of the process? First thing is that the investor usually invests in people, not the IP, not the particular game, not the staff, but in people, usually the founders, at least in the VC deals. So there are hardly no issues that could block the investor forever from investing in your company. These are rare cases when there are real blockers, because most of the issues can be sorted out quickly. If you have some mess in corporate documentation, if you have some agreements that need to be rewritten, amended, or terminated, it all can be done within this, I don't know, 6 weeks. The problem might be when there's some stuff with, I don't know, the source code of your game that is faulty, but also the source code elements can be replaced. So there are really nothing in the due diligence, or it's rare that something in the due diligence may really push the investor to say, I'm backing out. That's why it's not that important, the due diligence. How to prepare? If you're a VC studio, if you're a game dev studio that's the target of a VC investments, you might want to prepare. First of all, you need to mark it in your calendar because it's going to be some work. It's not like the lawyers are going to do everything. They're going to do most of it, but you need to scan some documents, you need to upload them in the VDR, you need to answer questions, you need to meet your lawyers, you need to answer the stupid emails, you need to put some effort. And my best experiences from the VC transactions were where the founders were responsive. So if their founders are responsive, if they are working together, the due diligence goes smoothly because if they're responsive, if they answer questions, if they meet you, if you talk about the problems on an ongoing manner, there are some things that you can sort out like this. And the investor's lawyer, they don't even have to, like, maybe not know, but it's not going to be a problem if you sort it out like on an ongoing manner. So yeah, you need to reserve some of your time to save the date in your calendar. Lawyer up, of course, you need to have some lawyers for the due diligence. If you don't have, and the other party does, the investor does, you're going to be wrecked. So we're necessary. Yeah, I am. Ask questions to your advisors. There are no stupid questions. You know, the founders, they might be confused. They might be scared. They might even forget to think about something. But we are here, or other advisors like your accounting and so on, are there to help you. So ask questions. Sometimes things are obvious to us lawyers, like very obvious. But they are not obvious to founders. Of course, it's our job to find these areas that not need to be covered and cover them. But let's be honest, lawyers also sometimes forget stuff. So if you ask about it, it's going to be beneficial for the due diligence process to run smoothly. List your assets and licenses. This is very important because the assets and the licenses are going to be checked when the IP is checked. When the IP of your game, the source code, the assets, the music, the licenses are verified, you're going to need to confess all your sins, like your copyleft license or the fact that you use some shady stuff, some stuff that comes from God knows where, nobody knows where the IP is. You use the AI to generate everything, every graphic to your game. Please don't do it. So yeah, if you put stuff together before the due diligence is made, it's gonna make your due diligence like 20% fast. No, 200% faster, really. I had this VC deal where the founders prepared like a gigantic Excel with all the assets that they had, and I looked at it like, God, this is gonna make everything smoother, and it did, really. So if you put some effort before the due diligence is made, it's going to really, it's an investment it's going to pay itself. Self-examination is a must. So you need to be aware where the problem is. And if you're a founder, this means that you have to engage your lawyer not only to answer the questions that the bad lawyers ask, but also to run your own due diligence. So to know where the problem is and to deal with it before the other guys come to you. Again, as much as you can, you should sort out during the due diligence process or even before, so the other guys don't come to you and tell you you're going to fix it now. That's like greater cost than you would have incurred if you'd done it before. Be honest to your advisor. So we're here to help you. We're not here to like laugh at you. This agreement's invalid. You're a loser. No, it's not gonna happen. So be honest to us, confess everything. If you use the advisory of your accountant and they told you to do stupid stuff and you did, and now there is problem, please confess it to us. We're not gonna laugh, we're not gonna shame you. And be reasonably honest to the other party. So in general, and I'm gonna be serious for a minute, it's not good to lie to the investor and to the investor's lawyers, because if you lied, it's a problem legally. But you need to somehow be reasonable in how much truth you disclose. Usually it pays to be, 10 minutes, oh gosh, sorry. Usually it pays out to be transparent, usually. But being transparent means that you need to find the right moment to be transparent. So you don't have to you don't have to necessarily run and say, "Oh, this is our problems, please, please, please." No, you need to find a problem. First, think about the solution to the problem with your lawyers, with your advisors, accountants, so on, and then come to the investors' lawyers and say, "Okay, we did our due diligence. We found X, Y, Z problems. Here are our remedies. We fixed these two problems by doing this and that. The other problems is not fixed, but it will be in a couple of weeks." And so this is being reasonably honest. Don't act hastily. So again, don't make rush decisions. Don't disclose everything you know at once. Don't make immediate calls with the other party. Be patient. Trust your lawyers that they're going to handle it. Let your business partners know. Of course, you need to remember about confidentiality, because of course, during the due diligence process, you're running a company, so the business must go on like usually. But some of your time, some of your efforts, some of your attention will go to the due diligence, to the investment process, negotiations, so on. Let your business partner know that there is something going on, that you're making some effort. Of course, maintaining the confidentiality again. But if you do not, they might you might have some problem, because they won't know about it. They will act as usual. For example, you can have less time to discuss some operational stuff with them if you're undergoing due diligence. So let your business partner know. Let them know that you might have additional requests, that they should reply quickly, like, for example, some information from them, some numbers, some agreements, some documents. Let them know that you might have questions like this, and you would appreciate that they answer quickly. Okay, I have so much no time. So what your advisors can do, first of all, understand your business. They need to understand how your gaming company operates, how the development process looks like, how the publishing deal is made and is conducted. They need to know everything about it, and if your lawyers do not know, we do, about it, you need to explain to them how the entire business environment of what you do looks like. Because if they don't understand it, it's gonna be a disaster. There's nothing worse than a lawyer who does not understand his or her client business. It's pretty common that the other party, the investors' lawyers, they don't understand, for example, game dev business. I had this situation, and it's tough, because even if you do understand, you can explain some processes, some stuff, I don't know, how the development process look like. And the other party, they don't know and they don't care, because they're gonna be paid anyway, per hour. you're gonna meet some concrete wall, and it's really not pleasant. But it's just not pleasant if you, as a lawyer who helps a game dev company, don't understand it. It's gonna be a disaster. Explain the process. Let your lawyers explain the process to you, how it looks like, where are the key obstacles, and how to overcome it. Identify key areas to be investigated. Be responsive as a lawyer, of course, and also your advisor should help you in doing self-examination. This usually means vendor's due diligence. Okay, so how much time do I have? Oh God, I'm always late. Sorry. So most important areas. Your IP, of course. What is checked? Chain of title. How your IP was transferred from the authors, from, I don't know, designers, artists, software developers, even QA guys, localization guys, to your company. If there is anything missing in the chain of title, that it might mean that your IP is not fully vested in the company, and it's the worst thing. Assets, of course, that's do you have the title, the license, the IP to use the assets? Source code and its elements. Does it have any open source licenses, elements? Do you use any unidentified elements of source code that you don't know where they come from? Do you use some shady plugins that suck data and transfer them God knows where with the grave violation of the GDPR? You better not to. Music, my brilliant colleague who is sitting somewhere there is going to say about how to use legally music in the video games. So the IP is crucial, of course, for the investor, because they invest in you as the founders. But okay, let's be honest. You're gonna develop some IP. You're gonna profit on the IP. So the IP must be like super clear. Corporate documentation. There might be mess in the resolutions. There's always something in the corporate documentation that is wrong. Usually, all these things can be sorted out pretty quickly. But if there's a mess, it needs to be sorted out before the deal is closed, or immediately after. Your publishing deal. If you already have a publishing deal, it's gonna be verified. And it's going to be checked. This is usually kind of a problem if you already have a publishing deal, because it's not so easy to change the publishing deal, to amend the agreement. Usually the publisher, if they're greedy, they're gonna come and say to you, okay, you have an investor, so how about some more money for us? So unless there is like really big issue in the publishing deal, it's not really a time and place to engage in the negotiations to change it. Agreements with your staff, that's pretty obvious. If you have too much umowa o dzieło, it's going to be a problem. Your agreements with contractors, your business partners. If you're a young studio, it's not going to be like too many of these agreements, but if you have some history behind you, they might compile to, there might be some additional agreement to check. Disputes, if someone sued you or you're suing something, that's going to be also X-rayed. And of course, tax settlements and accounting issues are going to be checked. They're very important because if there are some tax risks, that's for the investor, it's very important to understand them and try to mitigate them. And by tax, of course, I mean social security contributions as well. Okay, typical issues that might come out. IP is not fully vested in the target. There are some breaches in the chain of title, some missing agreements, some clauses that are written by accountants. Risk licenses, some copyleft software used, some licenses that you use and you breach the terms of their use. faulty agreements with the staff, so lack of IP clauses, some important, pretty common contractual safeguards are not there, like there are no confidentiality ensured, some non-solicitation, but these are the issues that can be sorted out pretty quickly. A mess in a corporate documentation, there is always a mess in a corporate documentation. Again, this is something that can be sorted out unless it's like the company's shares are invalid or something like this. Tax and social security risks, there are always some tax and social security risks in the young studio. Nothing is ever 100% smooth. But again, how much tax risks can it be for a company that operates like a year or two? Not much. So this is something that, you know, for the investor, it's not like, it's not going to be a red flag usually. They just need to understand how much of an exposure there is. Okay, so practical do's and don'ts. Be honest with your advisors and reasonably honest with the other party. Always present issues with the remedy plan. Be responsive. Try to remedy as much as you can during the process. Make sure all that is unremedied is disclosed so the investor knows about it formally. Don't make decisions hastily. Don't provide excuses. Don't be sorry. So don't put yourself in a position when you're telling the investor, okay, I'm sorry, I'm going to do it. Oh, sorry. No. Okay, there might be some problems, but we will have a remedy plan. Our lawyers will have a remedy plan. We're going to give you it in 2 days or maybe later, but we're going to sort it. Don't try to hide issues. That's pretty important. Don't be afraid of the other party, its advisors. And not to be afraid, for you to not to be afraid, you need to have some advisors of yours, because the investors' lawyers are they're gonna feel your fear, and if they feel, they're gonna bite like dogs. That's what we do. So selected cases. Do I have time? No. Oh shit. Yeah. 1 more minute. Okay, so for the cases that I went through with my clients, there were the cases that oh shit. For example, because I don't like to be put under pressure. For example, there were some agreements on the IP transfer from the founders to the studio, and they were perfect. They were written really well. Everything was perfect, but they were invalid because there were some contractual, some corporate restrictions were not met. Wrong person signed it. The accountant said it's okay, but it was not. They followed the advisory of the accountant, and they signed great agreements, but they were invalid. So the IP was not fully vested in the company, and it means it was still vested in the founders, which was not like a very big problem because the founders can still do it, and they can still vest the IP transfer to the company. But apparently there needs to be some cause for this transfer. There needs to be some money. So the company needs to pay money for the IP transfer, and that's a problem because the company didn't have resources. Apparently, in our case, they did have something, some cash in the pocket, like zaskórniaki in Polish, but there might be a problem if the company is empty. Okay, key takeaways. You can read it, but I don't have time to read it. Sorry.
Okay, thank you, Jakub, for your presentation.